Next item on our agenda is under new business, case 11-06, under item 4.1. It's a request for fine reduction from the Church of Scientology, 215 South Fort Harrison Avenue. Who's here on behalf of the respondent? If you could state your name, and I have a couple questions for the for our attorney before we go forward much further.
Certainly. Ed Armstrong, 911 Chestnut Street, Clearwater. I'm an attorney here on behalf of the property owner of the Church of Scientology Religious Trust.
Thank you very much. Mr. Salzman, just because on these matters that I know sometimes might involve some issues and it might be complicated, I'd like to clarify the board's options with respect to a request for fine reduction. If you can kind of just recap that so we're all approaching this from the same mindset.
Certainly. The board has the option to hear any matter for fine reduction. You cannot reduce it below the administrative cost. Anything in between the current number and that number is at the board's discretion. Normally, if you do choose, in the past, the board has required payment to be made within 30 days. Otherwise, the fine reverts back to the prior amount.
Okay. All right. And when you start out by saying if we choose to hear it,
yeah.
At that point, my understanding of it, just so we're clear, is that we have the option of considering it, or we have the written request. We've looked at that, and somebody either brings it up or not.
Right. These are all at the board's discretion.
Okay.
The whole issue today is at the board's discretion.
Thank you very much. Does anybody from the board have any questions, Mr. Salzman? No. So I'm inclined to hear what the property owner has to say, unless someone has. Okay. Mr. Armstrong, why don't you give us a summary or your presentation of this matter?
Thank you. I do have a presentation for you this afternoon, and I appreciate your time and your attention. I'd like to start out on behalf of my client with an apology to this board and the community. There was a period of time in which the property was in disarray and disrepair, and that did have a negative impact upon the community. There was also an expired permit. A fine is appropriate, and we are willing to pay today, dollar for dollar, for that period of time that the community was negatively impacted by the condition of the property. We believe that period of time would total a fine at the rate of $250 a day of $45,250. And that's $250 per day from June 25th of 2006, which was the Code Board's compliance date, through April 30th of 2007, minus the time required for the property owner to go back and get a new development order for the property. The city has agreed to that reduction in discussions with city staff. That's about a 4.5-month window of the time period in question. We'll demonstrate to you the importance of the April 30th, 07 date, and we're prepared to tender a check in that full amount to the clerk today in full satisfaction of the fine and also to waive our appellate rights in this matter. When you consider this case, what we ask you to do is to understand the importance of this building in Scientology. This building is the religion's global spiritual headquarters. It's, in essence, a cathedral. It costs literally tens of millions of dollars to build. Why did it take so long? It took about 12 years, beginning to end. We think that is actually a reasonable period of time, given the complexity of the building. For context, the Mormon Tabernacle in Salt Lake City took 40 years to build. The National Cathedral in Washington, D.C. took about 83 years to build. Let me walk you through verbally the timeline of what happened to the property and what brings us to here today. In 1998, the property owner obtained a certified site plan under the old Land Development Code. They obtained building permits in 2000, and construction started. Construction proceeded until 2004, when it halted. At that point, the church decided to do a dramatic redesign of the interior of the building and change contractors. The property over time did fall into disrepair, and the city expressed concern to the property owner. In early 2006, the city cited the property owner for an expired permit, and there's a code board hearing in March of 2006. At that hearing, Mr. Garriott testified and showed photographs. And his testimony characterized the photographs as showing the site littered with debris, overgrown, and surrounded by dilapidated fencing. We agree with that characterization. That was totally accurate at that point in time. Mr. Gary also testified that the permit in question did not cover any interior work for the subject property. Of course, the permit had expired at that point in time. This board found that there was a violation and imposed a fine of $250 per day. They gave the property owner 90 days to reactivate the old permit. The order is a little bit ambiguous, but the minutes clearly reflect that was the expectation and the deliverable was to reactivate the old permit. They also had 180 days to come into compliance. Everybody broke and went about their business. On April 3rd of 2006, Jeff Cronschnabel sent a letter signed by Mr. Garrett to the property owner saying, well, wait a minute, the building code's changed. You need to go back through the process. And he was exactly right. That is, in fact, what had happened. But importantly, on April 13th, approximately 3 weeks after the code board hearing, Mr. Garrett sent a letter to the property owner thanking them for cleaning up the site. I'd like to introduce that letter into evidence. Subsequently, the city and the property owner discovered that not only had the land development code, not only had the building code changed, the land development code had also changed. So the property owner had to go back, get a new development order, and then pull a new building permit under the new building code. During that process, there was email traffic amongst city staff. And in an email, Mr. Garriott suggested that completing the new shell and core permit, which the property owner was in the process of obtaining, would not satisfy the intent of the code board order. And Mr. Delk responded, well, no, that's not really the understanding. Our understanding was that it was to be a minimal landscaping plan, albeit code compliant, since the property was still an active construction site. And what we'd like to introduce into evidence now is that email chain between Mr. Garriott and Mr. Delk discussing the code board's order. A new development order was issued in November of 2006. What we call shell and core permit number 2 was issued in January of 2007. By April 30th of 2007, virtually all of the work contained in shell and core permit number 2 had been completed. There were a few odds and ends that later were attended to. At that point in time, the property had installed $300,000 worth of interim landscaping. Was it the final landscaping plan? No, it wasn't, because it was still an active construction site. Was it code compliant? Yes, it was. And what we'd like to do, I have a picture so telling. What you have here on those easels are photographs of the property from 3 sides. We just don't happen to have one of the 4th side in that time frame of April 30th, 2007.
If I may interrupt, can you give me the perspective on directions? Like the first picture is...
Sure. That elevation to my right there, that is the western elevation of the property.
Facing Fort Harrison?
Yes, facing the west. The second one there is the northern facade. And then the one to my left, that is the southern facade.
And these pictures were taken when?
April 30th, 2007.
That was the initial landscaping?
Yes, that was the temporary code-compliant landscaping plan that was permitted by the city, inspected by the city, and approved by the city.
Thank you.
I think one of the questions before you today is when the site is brought up to this level of compliance, does it justify a fine of $250 a day going forward until the entire interior of the building is done? We don't think that's what this board is trying to get at. We don't think it's consistent with the philosophy of this board. Another way of viewing it is the church could have saved $300,000, not done any of this, and just applied it towards the fine. But they didn't do that because they did not want to negatively impact the community. We believe to continue the fine beyond that is simply unfair. The few outstanding issues on shell and core permit number 2 did get merged into the master building permit for the entire site, which included the interior. The church proceeded to renovate the Oak Cove and Fort Harrison buildings to try to minimize disruptions to the parishioners and to the community. In June of this year, 2011, a certificate of occupancy was issued. An affidavit of compliance was issued, and that's what gives us the point of entry to come before you and ask for relief today. We don't believe that the Code Board's intent in considering an expired shell and core permit back in 2006 contemplated a full completion of the building. That's not what your building code requires. It requires permits and inspections. Your building code does not require a completion date. In preparing for this case, we looked at two questions. One is, generally speaking, how does the city handle expired permits from a regulatory standpoint, from an enforcement standpoint? The second question we ask ourselves is, how does this board typically react to a request to reduce a fine? And to help us with that research, we engaged Cindy Terrapini, the former planning director for the city of Clearwater, to spend some time going through the city's data, researching those questions, and we would ask her to come forward and share with this board her findings.
Good afternoon, Mr. Chairman and members. My name is Cindy Terrapini. I'm a planner with Florida Design Consultants at 3030 Starkey Boulevard, Newport Richey, Florida. I've been a professional planner for 30 years in the public and private sectors. I hold a Bachelor of Arts from Clemson University and a Master's of Science in Urban and Regional Planning from Florida State University. I served as the Assistant Planning Director and the Planning Director for a total of 6 years, and I have been qualified as an expert witness in the City of Clearwater and Pinellas County and many other jurisdictions, as well as the Circuit Courts of Pinellas, Hillsborough, Pasco, Hernando, and the Federal Court in Tampa. I wanted to talk about the two areas, the two questions that Ed asked me to research. And the first research question posed to me was, how does the city treat sites with an expired permit? How does the city enforce sites with an expired permit, which is the situation of the flag building? Are there other sites that are similarly situated to the flag building, meaning a site that has an expired permit and a stop work order on the same property? Briefly, our results are the following. We found 1,870 sites that had both an expired permit and a stop work order. However, only one of those 1,870 cases was sent to the Code Enforcement Board as a violation for an expired permit, and only one site had a fine levied against it for an expired permit, and that is the case we're talking about here today. I'd like to back up and tell you how we came to this conclusion and the research that we did. The first step was to figure out what the city had available electronically, and we met with the City Development Services staff to determine what data they had, and they did confirm that the building permit data was available electronically from 1985 to the present time. The second issue was to determine the time period for the study. We selected 1999 as the beginning point of the study since the church got their site plan approved in 1998, and by 1999 they were proceeding through the building permit review process, and as Mr. Armstrong mentioned, in 2000 they got their first building permit. So the beginning date of the study was January 1st, 1999. The ending date of the study is July 1, 2011, because we wanted to make it as current as possible. So the total time period studied is 11 and a half years. Then we requested building permit data from the city, and we received this data electronically. The first list that we got from the city was all expired permits during that time period, during that 11 and a half years. The data list included the permit number, the date the permit was issued, the date it expired, the type of permit, and then, of course, general information such as the owner, the address, and the parcel ID number. As you can see on the first document that I handed out to you, we found 13,129 expired permits. The second list we asked the city for and that we reviewed was an electronic list of all stock.
Slide's not on, if that's what you...
Excuse me, could we go to the projector, please? And it's the first page in the handout that you have.
Yeah, I know, just if anyone wants to see it.
Thank you. The second electronic list was all stock work orders issued by the city during the same time period, 11.5-year time period. And that data list included the stock work order number and the date it was issued, and the same general information, the owner, the address, and the parcel ID number issued by the property appraiser. That list contained 2,406 stock work orders. That's the right circle on the graphic in front of you. Then we wanted to know how many sites had both an expired permit and a stop work order, because that's exactly the situation the flag building is in. And what we found was there were 1,870 what we're calling match sites that had both. And that's what you see on the graphic in front of you. The next step was to say, well, out of those 1,870 sites, how many of those were sent to the Code Enforcement Board for violation for having an expired permit? So we did more detailed research on those 1,870 permits. Again, using the city's data, the city's database, what we found was, and this is on the second page of your handout, the most typical situation out of all those was that the cases were complied. 1,001 cases were complied, meaning, according to the city's definition, again, this is their data, we didn't make this up. We didn't categorize it any differently than the city did. Complied means that the applicant came in and got a building permit, so now their stop work order was not in place anymore because they complied with city code by obtaining a permit. 53% of those cases that we're talking about are in this category. The second most typical category is no violation. In that case, the city investigated and found that there was not a violation after they did their full research. 43% of these cases, 798 sites, were not in violation. A small percentage, the 1% or 28 cases, are in the received status. And what the city means by that, the case has just been opened and they might not have done enough research or investigation to know what really is the status and whether this case is actually a violation or no violation, or perhaps the property owner hasn't gotten a permit yet. So it's just sitting there. It's kind of a pending case. The last category, 2% or 43 cases, are active, and that means the violation is still in existence. That's the category that the flag building is under. So you can clearly understand the cases that have complied, the 1,001 cases that have complied, are not similar to us because the city says we're not in compliance. The 798 cases where there's no violation are not our similar situation because we are in violation according to the city. We're going to kind of put the received group on hold because it's just too early to tell about those. So we're not really similar to those. The city hasn't made a determination. So out of the 43 cases that are left, we really dug into these cases and evaluated the details of each and every case. What we found was this. In none of these cases was the stop work order issued because the building permit had expired. Not one. The stop work order was issued for a completely separate and unrelated matter. In addition, the stop work order in these 43 cases was issued an average of 6 3/4, almost 7 years after the building permit was issued. Further, our analysis of this city data shows that of the 1,870 cases, none of these expired permits were sent to the Code Enforcement Board as a violation for having an expired permit. The flag building is the only case we found where the owner was sent to the Code Enforcement Board as a violation for this particular issue. As you are aware, the basis for this case being heard for you today is due to the expired permit. The treatment of this property owner by the city to send an expired permit to the Code Enforcement Board and to place a fine and lien based solely on an expired permit is highly unusual in the 11.5 years of data that we evaluated, and it is the only case that we found in this 11.5 years that had that particular situation where an expired permit was the basis for going to the Code Enforcement Board. If I may, I would like to continue my presentation in a minute, but so that I don't forget and not have to come back up. I'd like to enter into the record. The CD has the list of all the data we received from the city initially and our analysis that we performed and all in spreadsheet. And this is a print of the match sites, the 1,870 sites that we were talking about. I'd like to enter that into the record, please.
Are you going to move on to the summary of the fine reductions, or are you still going to be talking about matching up the sites?
I plan to talk about the fine reductions, but I'm happy to stop and answer questions.
If you don't mind, I have a couple of questions. And I'm just trying to make sure I understand the data. While there seem to be 1,870 cases that have both the stop work order and the expired permits, the process the city had in place, which is either getting compliance or determining the extent of the violation, took care of all but 3% of those. Is that correct?
Yes, sir.
Okay. So the comparison really isn't to 1,870 cases. I'm just wanting to be clear. It doesn't seem to be to 1,870 cases. It seems to be to 2 to possibly 3%, because 1% of that is the received cases that are too new to really know of the 1,870.
Well, the reason the 1,870 is important is because we wanted to see how many cases in this time period had both a stop work order and an expired permit. Because that's our particular case.
I understand, and I'm trying to make sure I understand all the facts and as they're coming in.
Yes,
but if the city issued a stop work order and expired permit, and then the property was brought into compliance, that's not the situation we have here. That drops the 1,870 to 869.
And that's
right off the bat.
That's true.
Okay.
That's exactly.
The city's process that they had in place effectively took care of that issue.
Right, and that's exactly our point. There was 1,870 who were never brought to the Code Enforcement Board as a violation for having an expired permit. This property was.
But there was 1,000 that would have never come to Code Board because they were complied with.
Right, and it's our contention, too, that we did comply at a particular date. That's what Mr. Armstrong was talking about earlier.
I understand that and that part of it. I'm just looking at the numbers, and in the way you were describing it, if I understood your wording correctly, really this on your chart, which is in color, and I thank you very much, and it makes it very easy to understand. Sometimes it's difficult for me to grasp these things, but everything in the green and the yellow is really matters that don't really match up with the fact pattern we have with this particular site, because it was either complied with or determined not to be in violation within a certain period of time.
No, so I think you're missing.
That's why I'm asking the questions.
The point is, we wanted to see, were there other properties in the city that had both a stop work order and an expired permit?
That's 1,800.
There's 1,870 of those.
Right.
How did the city treat those 1,870 cases? Some of those folks complied.
Okay.
Some the city found were no violation. Then there's the pending group that, we kind of put in abeyance. But of all of those, 1,870 that had the exact same facts, a stop work order and an expired permit on the same site, only one case, this case you're talking about here today, was brought to the Code Enforcement Board simply for having an expired permit and had a lien filed against it. 1 out of 1,870.
Okay, understood.
Can I ask?
Yeah, Mr. Van Weesel started talking first, and then I saw your hand after, so let Mr. Van Weesel go first.
Not a statistician, but again, just trying to understand, of the 1,870, one half of those did comply,
Yes.
correct?
Yes, sir, they did.
So half the world complied. Is that accurate?
53%, yes.
Okay, more than half the world. Of the
54%.
when you boil it down to the 43 cases, which you call active, do you have any information regarding the disposition of those cases?
I have a variety of information about
Other than the
them.
one?
The 43 cases that have an active stop work order and have an expired permit, in none of those cases was the stop work order related to the expired permit. In other words, they were two complete. Happened to be the same site, but they had an expired permit for one type of work. They got a stop work order because they were doing work without a permit for some completely different type of work.
I understand that, but my question still remains, of the 43 cases, what was the disposition of those?
They still have an active stop work order,
Okay.
still active.
Okay, thank you.
But they were not sent to the Code Enforcement Board. Maybe I'm not making clear.
But
They were not sent to the Code Enforcement Board as a violation. They still have a stop work order that is still what the city calls active. I mean, it's still alive.
But we don't know what may happen in the future, so as of this time.
That's correct. And again, we studied a discrete period of time for an 11-and-a-half-year period. We ended the study on July 1, 2011, because we were looking at what was going on in the time period that the church was building their building. So we did end the study at that time period. Yes, sir.
Mr. Schultz, go ahead.
Mrs. Terrapini, I appreciate all the work you've done here. Statistics was not one of my favorite courses in college.
Mine either.
And I empathize with all this work you've done. But help me along here, and this is a serious question. We're here to look at case 11-06, which is a request for fine reduction. Mm-hmm. And that's all we're here to look at. To me, all these other cases are not relevant to what we're here to do. Mm-hmm. So I'm asking you, why are we listening to all that when we shouldn't base our decision on this case on something else that's happened in the past? And the city brings us these cases. We don't go out and look for them. They bring them to us, and we make a decision on that specific case. So why are we going through all this background information?
Well, in just a moment, when I finish answering your questions on the first part, I do want to talk about the fine reductions and the history, and that's an important point. You're correct. But we thought it was important for you to know that this case, the flag building, which was found in violation some years ago, I understand that, is highly unusual. It's the only case we found where the city brought a case, a site that had an expired permit. It's the only case we found that case was brought to the Code Enforcement Board. We thought that was unusual. We thought that was a piece of information you ought to be aware of, and hope maybe it'll enter into your decision, maybe it won't. We just thought it was important for you to have that information.
In my opinion, while that may be unusual, it certainly isn't germane to our decision today.
Yeah.
We can only respond to cases that we've heard. Mm-hmm. And if we haven't heard them, then I don't think it should be part of this discussion.
I do have one question for you just to wrap up that portion of it. Of the 43 cases that are active, how many of those encompass an entire city block with the structure, the scope of this one?
Short answer is I didn't look at every single site to see the size of that property. I looked at the addresses. The addresses are in various parts of the city. They're geographically dispersed. Okay. They're different owners. So I'm sorry, sir. I can't answer exactly.
That's fine.
I can't compare the size of this site to those 43.
All right. And I don't think we have any more questions on that portion of it. You want to go on to the summary of fine reductions, and I think Mr. Schultz's question is very relevant there. I would ask that in the context of that, and I'll make this statement out there, and this is just from my perspective as my role on the board and being a member of the board, because we do weigh in our personal experiences, but the reality is that this right now is this particular board. These fine reduction cases that you've got the summary on here cover numerous makeups of boards with different perspectives, and I'll personally state that when I came on the board, one of the first concerns I had was what we were doing in terms of reductions. And so, that being said, in the context of this, in terms of relevancy to this particular case, I see you've got statistics here, 32 cases, fines reduced in 28 of them, and additional, and correlating that to percentages. In the context of that, as to this particular matter, is there anything in the statistics that relates specifically to the property owner's conduct and how it should affect the reduction in the fine? Because that's really what we have to look at here. We're trying to look at what the property owner was doing, whether it merits consideration to reduce the fine or let it stay from what the previous order was.
Well, I guess maybe I can touch on that momentarily, Mr. Armstrong.
If I may, just for a moment, Mr. Chairman.
Sure.
I appreciate your point that the Code Enforcement Board has a changing constituency.
Yes.
That has always been the case, will always be the case. Yeah. At the same time, the only way we can evaluate this is looking at it institutionally. There's just no other way for us to go about it. What I would ask is your indulgence. Can Ms. Terrapini have 3 minutes to summarize her findings? Because I think it is worthy of consideration how this board has handled requests for fine reductions historically. You can put whatever weight on it you choose to, but can we have your indulgence for 3 minutes to get that testimony in the record?
I'll allow that from that perspective. I mean, unless there's a strong objection from any of the board members, I try to at least get information here so we can weigh things as fairly and as equitably as possible.
I promise you.
Appreciate it. Thank you.
Thank you, Mr. Chairman. The second issue that we researched was the history of the Code Enforcement Board regarding fine reductions. As you're aware, we're requesting a reduction from the original assessed amount of $451,500 to $45,250. Based on the board's past history, I will show you that this requested reduction is reasonable and consistent with past actions. We evaluated the fine reduction requests only since 2006, because that was when the fine was initially levied on this property, and we reviewed the board minutes through June 2011. So again, slightly different time frame than earlier. During the time period studied, there were 32 cases where the owner requested a reduction. Of the 32 requests for fine reduction, the Code Enforcement Board reduced the fine in 28 of those cases. Of the other 4, there are valid reasons why those 4 were not reduced. In one case, it was a repeat violator, case number 31-09. In one case, the property was still in violation, case 30-05. In one case, case 1509, the lien for the fine was invalid because the lien was filed after foreclosure, so the lien was invalidated. And in the 4th case, that was where there was no reduction, the owner requested the board to remove the lien in whole, and the board denied that request. That was case 3507. Also, of the 28 cases where the fine was reduced, 19 cases, the fine was reduced to only administrative costs. This is the absolute minimum, as you know, since administrative costs cannot be waived. The typical amount of the reduction for those 28 cases was a reduction in the fine, the initial fine to the fine paid of $93,000. In other words, 93%. In other words, the owner paid only 7% of the initial lien amount. When we looked at all 28 cases over time, cumulatively, the fine was reduced as compared to the lien amount by 85%. In summary, it's our belief that our offer to pay a fine of $45,250 is a reasonable amount and is well in that range given the history of the Code Enforcement's fine reduction. I'll be happy to answer any more questions that you may have, and thank you for your attention.
Thank you. Anybody have these questions?
Yes, I do. Do you have any indication from your study as to what the reasons were for those 28 cases having their fines reduced?
I do. In one, the property owner suggested a lower amount, and they demolished the building for compliance. These I'm going to look at the cases where you reduced, the fine was reduced.
And we do have a record of each case where there has been a reduction.
I guess I'll make a statement, and I can only speak from my tenure on the board. The fine reduction cases that I've been involved in, to the best of my recollection, have involved hardship.
That's not what the minutes indicate.
That's why I said I'm just making a statement.
Fair enough.
And I have a statement to make too. I'm going to concur with what you said. Having served several times over the years on this board, and probably been party to some of those reductions, but certainly not all of them, because I really don't believe in reducing fines unless there's a compelling reason. We've always said it's our job to bring people into compliance, and certainly not to be punitive about it if there's any way to do anything about that. When people show us that they blatantly do not follow the rules and regulations of the city, we go ahead and put those fines on, and we expect them to be carried out. When somebody comes into compliance and comes to us and says, I did the best I can, or I couldn't do it all the way because, and there is a compelling reason that they should not be held responsible for the rest of it, but we see they've made an honest effort and they've come into compliance with the city, then I think the board uses its heart as well as its head.
And that's what we're asking you to do today.
And show me a compelling reason.
These pictures right here. To the chairman's point, I've certainly reviewed Article 9 of your Rules of Procedure. There's discussion of enforcement and an elaboration of factors that this board should consider when considering a request for a fine reduction. I'd like to read those into the record briefly. Factors to be considered by the board in determining whether to reduce the amount of such fine or lien are.
Mr. Armstrong, could we
Yes.
stipulate to those? I'm going to have those in my PowerPoint presentation, and they're going to be the same exact factors verbatim.
Sure.
And then that way, if you would indulge me with that, we can stipulate to those, if the board's okay with that.
I'd have no problem if we're not repeating it and carrying this any longer.
Yeah,
If you're okay with that, I don't need it.
Sure. That's fine.
All right.
I'll go into
Then continue on. We'll hear the factors, Mr.
The facts we believe are functional compliance. We got a thank you letter from the city. I suspect you haven't been fining people to get thank you letters from the city for cleaning up the site. factors we consider, again, are, whether property's been brought into compliance. The city says it came into compliance June of this year. We believe it came into functional compliance on April 30th of 2007. There's no financial hardship here. I'm not going to go down that road. Whether there is a redevelopment proposal, there was. Whether their literal compliance is impractical, and it was because of the code changes, both building code and land development code, and whether the payment would hinder a proposed sale of the property, not the case here. The big thing is we came into compliance. There was no negative impact to the community. To extract the fine at this point would be punitive. Finally, the foundations of American justice are due process and equal protection, and we would just ask that you treat this property owner as you would treat any other property owner similarly situated. Thank you.
Understood. Thank you. Does anybody have any questions of Mr. Armstrong? Mr. Soto.
Let the record.
I'm sorry. Did you have a question? Okay. Mr. Soto, why don't you go ahead?
Let the record reflect. I'm providing a copy of the PowerPoint presentation that the city is going to put on right now to my colleague, Mr. Armstrong.
Very good.
And I will agree with Ms. Terrapani's assessment of this, and this being a very unusual case. Not very many buildings within the city of Clearwater are smack dab in the middle of downtown and take 12 years, 7 months, and 15 days to complete from the initial DRC site approval. What we have here is a situation where we have, and I think the PowerPoint will elaborate a little further on, is, and I know you might cringe a little bit by the use of a cliche, but I think it's very appropriate in this case to kind of get our heads wrapped around this really amorphous stuff that's getting thrown at you, for lack of a better term. But what we have is a self-inflicted shell game. And not the shell game in the traditional sense of the word, where you have shells and a ball and then they kind of switch them around on you. What we literally have is a shell of a building that has been wrapped up into bigger and bigger building permits, and that was solely a decision on the entity here, the Church of Scientology, in its effort to, I guess, get this project completed. So with that said, Mr. Garrett, if you can go to the next slide. What I've done is put together here a time frame for you to kind of make heads or tails of all these facts and all these issues that are being thrown at you. The first one, and the most important, I think, is the issuance of the first permit. That's BCP 1999-06560. We'll just call it Permit 1 for brevity's sake. And this permit, issued in March of 2000, was to construct the shell and the core of the building. That's all it was. It's a shell building permit. Now, I know you guys received, the board received a brief, quite a voluminous brief. I'm sure you had quite the time reading through that. But in that brief, in the footnote there, specifically footnote 9, page 4, my colleague concedes that the reason why the permit lapsed, or maybe one of the reasons why the permit was allowed to lapse, was because the church wanted to do internal planning, or for internal planning purposes, and to change general contractors. I want the board to be cognizant of that fact going through this, because it's going to obviously be prurient to the self-inflicted shell game theme that we'll have running through this presentation. Mr. Gary, the next slide, please. Here are the photos of the shell of the building and the surrounding area as it looked at the time of the Municipal Code Enforcement Board hearing back in 2006. As you can see, it's an active construction site. Well, for the most part, it had been, I guess, abandoned at that time, which necessitated the city taking action to bring the church to the Code Board to address these issues. Leave it on that photo there for a second, if you would, Mr. Garrett. There, I believe that's the north side of the building. It's an access point that I think was left open there. Just to remind everyone what it looked like, I believe that was on Pierce Street, if I'm correct. It's facing Pierce Street. It's the north side of the building. Next slide, please. Again, more photographs of the exterior of the building, the shell, plus the surrounding construction site. Now, we get to the point in 2006 where we have the notice of violation issued for an expired building permit. Again, for the expiration of building permit 1, which deals with the shell of the building. We had our hearing in March of that year, March 22nd to be exact, 2006. Then, after this hearing, the Church of Scientology had to make an application, which was referenced here, for a flexible standard development application, which was filed in April of 26, since the church's initial plan, which was approved back in October of 98, had expired. So, essentially, it took 6 years. My math isn't the greatest, but from 98 to 2004, that's 6 years. They let their site plan expire. They had to go and get a new one, which obviously made their acquisition of the revalidation of the building permit difficult. We concede that. Next slide, please. The exact order of the board back in 2006, and I have a copy of it if it's here, but I think it's very clear on its face, doesn't leave any room for functional compliance. I think it requires complete and utter compliance, as it always has and always will. The order, and I quote directly from that order, the church is to correct the aforesaid violation by activating the required permits within 90 days, and again, that was June 25th of 2006, from the date of this board's order, and is required to complete work and obtain required inspections within 180 calendar days. Again, we're talking about the very first shell permit, Permit 1. Next slide. Continuing onward, we had the DRC review their flexible standard development application on 8/31, and a development order was subsequently issued in October of 2006. Then a subsequent building permit was applied for in 2006. We'll call this one Permit 2. And this new permit application covers not only the shell and core completion of Permit 1, but it also adds a whole bunch of other stuff that's listed there: curbs and sidewalks, waterproofing repair, temperature irrigation, additional sod, stairwells, doors throughout. This was applied for in October of 2006. Now, moving right along, 2007 to 2008, we have, again, I think some more details on that Permit 2, again, issued in January of 07. It wound up expiring in October 21st of 07, and various extensions took place. I want the board to keep in mind that at no time was the work that was for the shell permit, Permit 1, was there ever any final inspection done for that work, nor was that completed, I think, in any way is the best way to put that. Now we come to Permit 3. Again, a new permit is applied for, and this application is for complete interior finishes with air conditioning, electrical distribution from core utilities, smoke control, exterior landscaping, and hardscaping. Permit 1 work was again subsumed again into Permit 3, which is the largest of the three. That would be the master permit. Again, at all times, the Church of Scientology chose to progress this way in subsuming earlier permits by their own accord. All while this is going on, we had the Municipal Code Enforcement Board hearing in 2006. All while this is going on, the church is also building various other construction projects throughout downtown Clearwater. And all while this is going on, they are receiving quarterly statements giving them notice of the various fines that they're accruing for having let lapse Permit 1 and not having obtained all the work necessary to complete that out. Now we're in 2009-2011. Permit 2 was subsequently closed, which means it was a notation in the file, which means all the work from Permit 2 is going to get rolled into Permit 3. And so that's it right there. Permit 3 was issued in June of 2009, and a certificate of occupancy was finally issued after all this in June of 2011. Next slide. So the flag building was ultimately completed with all final inspections 4,610 days after the initial October 98 DRC site approval, And it took 1,717 days to, and again, using the board's order, to complete work and obtain required inspections. And again, that was in reference to Permit 1, as was required by that board order from 2006. Next slide. Now, where does the self-imposed shell game come in? Well, there's some aggravating circumstances that I want to bring to everyone's attention, and this will fall in line with the board's policy in reducing these fines. And again, we understand that there's an unusual circumstance here, and the board also, just I think as a pause for the moment, the city is willing to concede and modify the total amount of $451,500, which was what the fine accrued to, down to $413,500. $413,500. Thank you. It's a lot of numbers there.
Let me interrupt if I may, and that is for that time period in 2006 where they had to go through and get the new development order and that process.
That is correct. That is about a 4.5-month, 5-month period, I believe, in which the city concedes that it would have been impossible for them to have reactivated all permits and gone about its business. So we concede that the city is not opposed to reducing it to $413,500 in light of that. Going back to the aggravating circumstances, which will dovetail into the board's historic policy on fine reduction. Again, the expiry of Permit 1 was due to internal planning changes and change in contractors. The internal planning changes, I know they will likely say that it has to do with something with the shell, but at the end of the day it doesn't, and it has been historic in Mr. Garriott's support and I think city support, in which the city wanted the shell complete. Completion of shells is something that's very common in buildings. It's done all around the world. Oftentimes buildings will be left with shell completed, and they will oftentimes seek tenants to occupy the interior, and once they get a sufficient amount of tenants, they'll likely go forward. I understand this is an institutional building, but it's not we weren't asking them to do something different than what is commonly done or routinely done in these circumstances. Again, another aggravating circumstance, the church chose to subsume work required under Permit 1 into larger, more expansive building permits, Permits 2 and 3. Again, it's important. All while this was going on, they were receiving quarterly fine statements indicating they were accruing these fines. They likely could have gone about this situation a little differently and could have maybe completed the shell permit, but for whatever reason, management or otherwise, they chose to go this route. Since 1998, the church has chosen to work on 8 other construction projects throughout the city of Clearwater valued at greater than $500,000. Some of those projects are listed in the brief that was submitted. There are a few others. I have a listing here. There's the Sandcastle renovations. There's the Fort Harrison retreat. I believe there were various other projects all throughout the city of Clearwater that the church chose to focus on in light of, again, this large, expansive one-block building being unmaintained, unfinished, essentially since October of '98. The church, at no point that I was aware of, informed the MCEB or came back to indicate that they were having difficulty achieving compliance due to building code changes or changes in the certified site plan. With respect to the change in the building codes and how that impacts the shell of the building, Mr. Gary can correct me if I'm wrong, but the only changes that I guess would have impacted the shell of the building that would have maybe necessitated some drawing revisions were those specific to structural wind loading, and which is essentially the windows, and the other one would have been the heating, ventilation, and air conditioning design.
I'm Kevin Garrett with the Building Department, Planning and Development, and I wouldn't say the only changes,
or the most
but
significant?
The majority were wind loading concerns and smoke evacuation, HVAC changes that they looked at and did.
Before we go any further, I do have a question. I may interrupt you for just a moment. The previous slide that you showed dealt with the church never informing the city. You said earlier that church was getting quarterly statements about the fines that were occurring. Is that correct?
Sure, that's it's common practice with all of our violators.
If in 2007, April of 2007 is where I believe Mr. Armstrong was arguing as far as when they believe came into compliance, even though a affidavit of compliance had not been issued because the city's position was that it had not been brought into compliance at that point in time, could they have asked to come before the board at any time from 2007 to now to say, hey, we believe that we complied with your order and we're asking the code board to weigh and evaluate this about whether we're in compliance or not? Is that possible within our framework? Is what I meant.
Requesting a hearing, yes. Appealing an order or rehearing is not. There's a 30-day period, but absolutely.
So they could have requested a hearing. So from April 2007, they're getting quarterly statements saying the fines are accruing.
That is correct.
And we're in August of 2011 at this point. I just want to make sure I understand when they could or could not have done something, when they did or didn't do something, and what's self-imposed or not.
I don't think that's correct.
And that's what I'm trying to find out.
You had to be in compliance.
Oh, right. Right.
You changed it. The rule used to be that you had to be in compliance before you could come up for a fine reduction. That rule was subsequently changed because what was happening is you were having properties where people were having fines that were greater than the value of the property. And then you were running into a problem. You subsequently, I don't have the time period, changed that to allow people that were not yet in compliance to ask.
Thank you, and I think that change came before I even came aboard with the city. Yeah.
And let me clarify a point. I appreciate you for bringing that up, Mr. Salzman, because that's what I really want to understand, because I think it's relevant to the overall consideration here. Even though I'm not saying they could have come to us for a fine reduction, but if they felt that let's just pick a date, after April 2007, let's just say September of 2007 or August, so it's 4 years ago today, that they were in compliance and they're getting this statement unjustifiably, regardless of what the fine amount may have accrued to, did they have the right to ask for a hearing and say to the board, hey, listen, we did what you told us. Are we reading this order incorrectly or not? So that way the board could either clarify if it felt it needed to or things would continue to accrue. Because you got 4 years of fines running and sitting back when they think, according to their argument today, when they think that they're in compliance. And I just want to know what their remedies were or options were.
No.
Okay.
It would not even be brought before you.
Okay.
They were not in compliance.
Okay.
They couldn't even ask. It would not be addressed.
Okay. Very good. That's what I need to know. Thank you.
That was a two-step process back then, too, which was one meeting you would meet to decide whether you were going to hear it, and the second meeting would be to actually hear it. I believe back then, if they didn't meet the qualification, then it wouldn't go to the second step. But if you wouldn't even get past the first step, we'd say they're not in compliance. There's no need to discuss this. We just have to check on the dates. I don't know if you have those
as to when the policy had been changed. No.
I don't think I have that in front of me.
Okay.
But I think if we get the slide back, because there's going to be just a few more points in the slide, and then I'm going to address some issues in the brief that the board, I'm sure, has had an opportunity to mull over as well. This brings me to the next portion as to, and I think this will address the factors as to what the board historically has taken in seeking redress or with violators that are seeking redress of these fine amounts. And here we have basically verbatim the policy factors that are taken into account, come straight from the board's policy as to what factors are to be balanced out. Now, historically, what we've had in terms of violators that have come in seeking this kind of redress, generally, they tend to be property owners that are residential in nature, a good majority of them. They're individuals that have come into hard times. I believe Ms. Terrapini mentioned one where a foreclosure took place, and that essentially extinguished the city's. At no time, I believe, well, since I've been aboard with the city, but I think even with Mr. Delk and Mr. Garriott, they would also concede that at no time have we ever had an individual property owner, whether institutional, commercial, or otherwise, take 12 years to complete a project. And I think this is absolutely an unusual circumstance, and as such merits, obviously, I think a very cognizant and very calculated assessment of the penalty components that are obviously incorporated by statute into this form, if you will. At this time, I just want to address some of the issues, and I'll conclude very briefly. I know their brief mentioned one of the first issues was the impossibility of being able to comply. The city obviously concedes that for 5 months it would have been impossible, but with regard to possible modifications to Permit 1, we've mentioned the wind loading and the HVAC redesign. Those aren't impossibilities. At the time that the board was brought before the, that the Church of Scientology was brought before the board, they were represented by both Mr. Uli Hubert and Mr. James Bond. Both of those individuals reaffirmed that they felt that 90 and 180 days was sufficient, even back in 2006, albeit there was a change, the site development plan changed, but still, even then, they still conceded that that was sufficient. They didn't blink an eye. Yeah, we'll get it done. That was very, that was pretty adamant there. Also, they provided in their exhibits, there was a March 17, 2006 letter made to Steve Verall. I believe that is in their exhibit. Doesn't look like it's an exhibit. It's in Exhibit A. And that letter to Mr. Steve Verall obviously explains what was expected of the church. In the first paragraph, they're referring to landscaping. This is a theme that was brought up by Mr. Armstrong constantly, the landscaping. Well, what we had here was a construction site that needed to be addressed, that was an eyesore, and what was agreed upon was a limited, and this is taken exactly from that first paragraph, last sentence, or second to last sentence. That agreement required a limited and reasonable temporary landscaping and ground cover, along with removal of the majority of the chain link fence to the said property. At no time did compliance get met by sheer planting of plants and setting up of sidewalks. You still had a shell that went without inspections, or that was never finalized. And so it wasn't an impossibility. It could have been done. They chose not to. And I think that's going to be that's in the evidence. The other argument that I think was brought up is that they had functional compliance. With all due respect to my colleague, Mr. Armstrong, that's a legal fiction. You're either compliant or you're not. There is no functional compliance under the code. You either get the shell of the building done and all the related site issues with it, or you don't. And they were getting constant notices of that, and they chose not to. They said April 30th, 2007 is what proves their functional compliance. Well, what proves that? The photos of sidewalks and landscaping? The shell still wasn't done, and that's the main reason why they were brought before the board back in 2006. So while code compliant, the landscaping wasn't what was required by the site plan. It still doesn't address the expired permit, which lapsed in November of 2007 and then subsequently was extended numerous times. There's a footnote, it's footnote 10 to be exact, in which they talk about their functional, again, their noncompliance, because that's exactly what it is. It's noncompliance, where they elaborate on their noncompliance. And I'd like to bring the board's attention to that footnote, and that's footnote 10. Now, the sentence that prompts the footnote is the city, and that's in the last paragraph on this page 6 of the brief. The city conducted and passed inspections of shell and core permit 2, including landscaping and sidewalk final inspections. Great. We're glad that they did that. It's obvious that we were ecstatic, as the city was ecstatic. They sent thank you letters. But in the footnote, various other components, and they acknowledge this in the footnote, of the shell were incomplete. It consisted of, and this is about halfway through that footnote, consisted of building, interior stairwell, firewall doors, engineering, temporary driveway for construction vehicles, plumbing, mechanical, handling drains, exhausts. There's various other inspections, and I think Mr. Gary, if you'd like to pick his brain on it, can talk to you guys till the cows come home on how all this process works. But the bottom line is the necessary inspections and permits as required by that order were never done for the shell of the building. I think the intent of the order is clear. reactivation within 90 days, final inspection and necessary work within 180. Neither was done. There's an April 3rd, 2006 letter that's signed by Kevin Garriott on behalf of Jeff Kronschnabel. That one also further details, obviously, the change in the building permit. But what it does do is it explains to them in the final paragraph that if they submit permit application to the Development and Neighborhood Services Department, the permit application is completed, a permit will be issued, and to complete the permit, you must have inspections done and passed. Once all inspections are passed, the permit will be closed. Closing the permit will indicate compliance with the Municipal Code Enforcement Board order. Again, it's been reaffirmed over and over again. The evidence shows it. For the reasons I've mentioned before, other code enforcement cases of reduction have never been as egregious or as, I guess, distinctive as this one. And I certainly appreciate the fact that in the brief they mentioned all the different buildings that they built from 99 to 2011, and I appreciate that they've done their share, I guess, to beautify downtown Clearwater. But what that indicates to me as just an objective individual is that they've chosen to prioritize other buildings before completing the flag building. And they did that, again, at their own volition. For these reasons, the fine should not be reduced to $42,250. The city is supportive of reducing it to $413,500. That's all.
Thank you. Does anybody have any questions from the board of either Mr. Soto or Mr. Garriott?
When the church was receiving quarterly notices from the city, were they talking with our inspectors? Were they talking with our city people about what they wanted to do, what they were planning to do, why they were ignoring that situation?
Again, I'm Kevin Garriott with Planning and Development Department. It is rare that we do not see a Scientology representative in our office daily or every other day, at least weekly. We had numerous meetings on this particular project and on the overall downtown projects that they were doing, the apartment building down the street, the sandcastle, the Oak Cove is what this is called over here. Their parking garage, their chiller building, their overall plans were in total communication with us all the time. So there is always, we have a very good working relationship with them, always have, and we're always talking to them. So yes.
At any time during those conversations, did they ever try and assert compliance, or that they have achieved compliance, requesting that you oversee that or sanction that or
not to my knowledge, no.
During it.
You just got all the construction going on, and there's been a lot of it, and they've certainly changed the face of downtown Clearwater. But my question is, didn't discuss the fact that they were being fined and that these fines were accruing, and they thought it was unfair, or they wanted to stop, or how did they go about showing that they thought they were in compliance and see what the city said to stop the fines?
It was brought up throughout the years at different meetings and discussions, a reminder to them that the fines were still accruing and were still running. They were aware of that, they acknowledged that, and basically indicated that they would choose to deal with that at the completion of the project.
All right, so
now, I don't know that we have that in writing anywhere.
Now, again, that would be reflected, I think, that rationale would be reflected in one of the emails that I think was included as an exhibit in your, in the petitioners or the briefant. I believe that was I think that's Exhibit C. And if you're referencing to, I think, the state of mind of dealing with it when they would complete, I think it might be in that Kevin Garriott email, Friday, September 29, 2006, 3:44 p.m. Let's see. I believe it would be the first, second, third paragraph down. Let me just make sure. and I quote, I stated buildings all over the world build out the entire building and site and then lease it out as they get tenants. They don't wait until the last tenant space is full to do exterior landscaping or site work. He acknowledged, and I believe he's referencing Mr. James Bond, he acknowledged, however, stated that they do not want to do it that way. I also stated I don't believe that the code board order will be met by that. He did not seem to have much comment on that. I believe they feel they will pursue forgiveness of fines at the Code Enforcement Board after they finally complete the project in an undesignated year. Well, that undesignated year came in 2011.
So, Mr. Garrett, let me just to be clear, and I think you were clear, I just want to make sure I'm part of the record in this respect. You did, and the city did bring up to them the accrual of the fines, and in general, what was just read was the response that you would receive whenever the issue was brought up?
Absolutely. Numerous times we brought it up to make sure that they were still aware of that we were all on the same page, and everyone was keeping track of what was going on there. Yes.
And to your recollection, there was never an instance that you can think of right now that they brought up themselves about the fines? Where the Church of Scientology commented to you, let's talk about these fines, or we think that we've achieved compliance. Is there a point where they brought up, other than perhaps on their own behalf, without you all bringing a discussion up?
I believe there was some. It's been talked about for a long time, and there has been something within the last several years where I think they even come to City Hall and had a meeting with city manager and maybe some other folks and discussed that, the leaders of the city and the leaders of the church organization. Okay.
That would be for someone else.
But I don't know the details of that.
Understood.
But and then again, that isn't related to the lapsed permit 1. We're talking about in reference to permit 1. No compliance, perceived compliance, functional compliance, any legal fictions of those kind. Were they ever espoused by the Church of Scientology at any time when you've had these discussions?
When they completed construction about 2 months ago in June.
All right. Does anybody from the board have any further questions of Mr. Soto or Mr. Garrett? We've gone on for a bit. I'd like to give both sides a few moments to do just a quick summary so that we can kind of put things in a pecking order. I don't have to, but I'm going to do that. I think that if we go for just a few minutes each and be respectful of that, I'm not going to say that you've got 2 minutes and 36 seconds or something like that, but if you can kind of just sum up, and that way we can then deliberate among the board and decide what we're going to do in this instance.
I would like to ask Mr. Gary out 3 questions, if I could. They're brief, and they are relevant.
You are entitled to that.
How are you, Kevin?
I'm good, thank you.
That's one.
That's one.
That's one.
2 more.
Kevin, going back to our meeting, the Code Board meeting in March of 2006, and you showed photographs of the site. If it was all about an expired permit, why were those photographs relevant?
Because it's showing that the project is not completed and it's still a construction site. That was our point, to show that that the building is not completed.
You're very familiar with your building code, obviously. Does it require, I'm going to phrase my question very precisely, does your building code require completion of a structure within a certain time frame?
I will answer that this way, in that a permit is good for 6 months or 6 months past the last approved inspection. So it does not have a requirement that says you must complete within 3 weeks or 3 years or 30 years.
That's what I was getting at. Your code doesn't require the completion of the building within a certain period of time. And do you recall sending an email to Mr. Cronsnobel on February 2nd of 2009 discussing the inspections on the shell permit, which would obviously be shown for permit number 2?
I have no idea. We've got 12 years of history here.
I'm sure there were a lot of emails. The record is
there were a
complete
lot
with
of
emails. I would ask that you please read the yellow highlighted section of that email that you sent to Mr.
Who is that email between? Just if you can give me that basic information first, and then go ahead and read what he asked.
Okay, this first one is from Jeff Cronsnobel, which was the director of the department at that time, to myself and Assistant Building Official Neil Leckers, Reports that furnishings are going into the flag building late at night. Questions raised, can they do this? My response back was, I saw cars there the other day. Also, I asked inspector and was told construction storage, which would be okay. It is too early for any furnishings as nothing inside is done. However, they have passed their inspections on shell permit.
Can you that last part, can you please? The highlighted yellow part?
However, they have passed their inspections on shell permit.
And the date of that email?
Was Monday, February 2nd, 2009. 2009.
Okay. Just one housekeeping matter. Let me enter the brief into the record. I don't know if it's automatically put there or not.
We've included in the package, so we'll just certify it in the record.
Yeah. I didn't want to leave that out. Given the hour and this board's patience, I'm not going to go through all the arguments yet again. You know what they are. Seen the pictures. We functionally complied. There's a lot of discussion from Mr. Soto about the fact, well, the permits changed. The permit changed. They had to change. The building code had changed. There was no alternative but to change the scope of the permits. We had to do that. We had to do that. We think that the intent of this board is not to be punitive in the community, is to bring people to compliance. You've heard the testimony from Mr. Garriott. Your building code doesn't require a completion date. It doesn't. That's compelling evidence. These pictures are compelling evidence. We would ask that you weigh these factors in deciding whether to reduce the fine currently imposed on the Church of Scientology Religious Trust. Thank you again for your patience. You guys have been a great audience. Thank you so much.
Thank you. Before you walk off, does anybody have any questions of Mr. Armstrong before the city presents its final wrap-up? Or does the city have a question? Okay. Before the city, Mr. Armstrong, quick questions, two questions for you. The specific question that you asked Mr. Garriott dealing with completion, what is your definition of completion? Is it the issuance of the CO or some other factor related to the structure?
In my view, it's the issuance of a CO.
All right. And when you say that the permits had to change in your wrap-up, and I'm just, again, trying to get the facts here so we can deliberate and make some decisions here, but did the permits have to change to the extent that they did change? The city's arguments were that the church, of its own volition, expand the scope of the project, change the direction of the project, and it could have completed the shell permit and then either applied for or done other things to get the rest of the project approved, kept things clear and separate with respect to compliance of what was put before it. And I'm just trying to understand in terms of you say had to change. I'm just trying to be clear on the had to change was because of the scope of the project changed or had to change. I know they had to get a new permit. I know that the code changed in 2004, and are you asserting that there wasn't the opportunity to get another shell permit of the similar type, similar scope that would have met compliance with the code board, or that was unavailable to you in 2006 when the church was doing that?
With your indulgence, I'd like my colleague, Ms. Cole, to come forward. She has spent hundreds of hours researching the voluminous files, and she is, as between she and I, she is the one who has a better working knowledge of the exact differences between what we call shell and core permit number 1 and shell and core permit number 2.
And I'll allow her to come up, but my concern is I want to keep it limited to the questions I just asked, which is basically, was a permit of the same type and character of what was originally in shell permit 1, with the exception of whatever tweaks might have been necessitated by the new code, available in 2006 for the shell permit number 2, which I believe was issued in January of 2007 when it was all said and done with? Or were there things in that permit that was actually secured that were broader in scope that didn't have to be in there? And that's, I want to keep it narrow to that because otherwise we'll be here the whole day.
We understand your question and we will answer as you have framed it.
Okay, thank you.
To my knowledge,
State your full name, please.
Katie Cole, 911 Chestnut Street. To my knowledge, and analysis of the permits, they were substantially similar. As part of the code change, the city required the church to present them a detailed analysis of the differences between the 1999 permit, what would be required by the 2004 code, and therefore what should be included in the 2006 permit. This analysis also included having to go into the as-built building, go through the building, and determine what could be included in a new shell and core permit based on what had already been constructed. There were certain items that had already been constructed because in 1999, and excuse the length of this explanation, in 1999 when shell and core 1 was permitted, subsequently, prior to 06, there were also some interior permits that were issued, so there had been some interior work that was done. That interior work necessarily tied in with some of the shell work because of how it was done. So the analysis of what was going to be included in shell and core 2 was quite detailed and quite specific, and the minimum amount of things that needed to be in shell and core 2 were put in shell and core 2 with the intent of meeting the code board order and finishing out the project. There were certain things in shell and core 1 that couldn't be included in shell and core 2 because of the reality of having a building there and then having to make other changes. We do have a copy of that report and correspondence between the city and the church in regards to why certain things were included and were not included.
Could you take us from 2 to 3?
Sure. Shell and core permit 2 was applied for and received by the church solely to comply with the board's order, and the master permit is what we referred to, was the basically taking the final site plan based on the new development order and all of the interior build out of the building. So it had the final landscape and final hardscape that was included in the site plan and all of the interior of the project.
From the issuance of permit 2, how long did it take to finish the project? What in timeline?
The permit was issued in January of 07, and the project was finished. It got its CO January of 07, and June 2nd of 2011 was completion. So 4.5 years.
And these pictures were taken in 2006?
2007, April of 2007. So this was the landscaping that was permitted with the shell and core 2 permit.
And that's when all the fencing and they took the boards off the doors?
No, actually, immediately after the code board order, in the letter that Mr. Armstrong presented in April of 06, there had been other temporary landscaping installed just because of the agreement with the city. And that was when some of the other construction-looking things came down, the fence and such.
That temporary landscaping, in your opinion, functionally or in reality complied with the order?
It was code compliant, and it complied with shell and core permit number 2.
But not with the board's order, is the city's contention.
The argument is that you functionally complied with the city's order, so I guess that better stated my question.
Any further questions for the property owner? If not, Mr. Soto, did you have questions of them, or do you want to go ahead and do a quick summary?
I have a few questions of Mr. Gary, and then summary.
Please do so and keep it brief.
Mr. Gary, in your opinion, when did they pass inspections on the shell of this building? When were final inspections done of the shell?
I believe that would still be in June of 11. I don't believe that everything was completely done because some things from earlier had to be redone and updated and upgraded.
Okay. With regard to shell permit number 1, was it necessary, let me rephrase it this way, could the Church of Scientology have petitioned or applied for solely a shell permit to address the board's order?
Yes, I don't see why not.
Okay. And at no time was there a requirement that a CO be issued for the entire building. It was only for the shell, correct?
correct, and I believe that's the way the order states.
Okay. And in the past, I think your willingness in these discussions was that you'd be willing to allow, I think, an access point in light of their work on the interior, but the adamant, I think, stance was always that the landscaping, everything on the site be completed and the shell be completed. Would that be correct?
Correct.
Okay. I think...
Before you go any further in terms of summary, to follow up on those questions, so if I understand your responses correctly, Mr. Garrett, a CO could have been issued for a shell while other permits were active and ongoing construction took place on the inside, in the interior, correct?
We would probably issue what we call a conditional CO. It's temporary. It says that one part of the building is done.
And that conditional CO would have been enough to comply with the board's order?
I believe it would be, yes.
All right. Back to you, Mr. Soto.
Okay. What I think here, and I think the evidence presents both my PowerPoint and I think the brief that was submitted, is the evidence shows, obviously we have a highly unusual case, but a large part of this was self-inflicted by the property owner. Instead of playing the traditional shell game with the nice shells in the ball, we have obviously the shell of the building being subsumed into bigger and bigger permits, and that's obviously at the property owner's own volition. They chose to do it this way, and they chose to address it in that email that I cited at whatever date came about for completion of the entire building. That ultimately wound up being 12 years later.
Thank you. Does the board have any questions before I open any of the comment for our deliberation? There being none, and it ends the public comment portion. Now, as far as the board goes, instead of going straight to asking for a motion, oftentimes on more complex matters kind of gone down the list, but is there somebody who would like to make any comment so the rest of the board can consider it? Right? Yes, go ahead.
I just want to bring the board back to your rules.
Okay, yes.
Back to the factors that you must consider in doing this, because I don't want people to get lost in some of the issues or the side issues.
Understood.
In your reduction.
That would be appreciated.
And I know one of the issues came up as to whether or not they said they were in compliance or not in compliance. I would just say one thing to you. In your factors, one of the things to consider is whether or not they are in compliance at that time. So whether or not it's strategic or not strategic to go before you or attempt to go before you beforehand, they're in compliance, and that's a factor to consider. How long it took compliance, those all issues are part of that factor. But I want you to look back at your factors that you must consider in the reduction, nothing else other than those. Otherwise, we'll be sitting here with a further litigation that's unnecessary. So I just want the board to go back to your factors when you consider those.
Do we have those in our binders here, or is that something you can just kind of...
It's in Section 4 of Article 9 of enforcement.
I have a copy of it, and if it helps, I can put it on Elmo.
Yeah, I think that would help.
Do you have a page number?
For the record, Elmo isn't the fuzzy Sesame Street character. It's our transparency machine for whoever's watching at home.
Because I know you've mentioned some of them, hardship, some of those, but I think you got to look at all the factors.
Does anybody?
Now that you said efficiently scared me, gotta figure out what it is.
Now, it's underlined, I guess, the part where it says factors should be considered, and then it goes to the
Do you have a magnifying glass?
Yeah.
In what section? In what section?
Well, that's why I'm looking for it in the book, and
We haven't.
Rules and regulations.
Thank you.
Would it help if I brought it up back in the
okay.
PowerPoint?
Right, rules and regulations.
1101.
Article 9 enforcement, Section 4.
There you go.
Okay, I just, okay.
Must be in writing, in case.
And in my book, it has a bunch of red line markups. But I found it, though.
Would you bring up your PowerPoint? I'm sorry.
I can do that. PowerPoint would be computer,
Okay.
and then...
Well, I'm certain people are tired of hearing my voice. I think I'll read it aloud just so that we kind of all have it sink in. Please read along. The factors to be considered by the board in determining whether to reduce the amount of such fine or lien are: 1, whether the violation has been brought into compliance regarding the violation cited; 2, whether extreme or undue hardship is shown regarding the payment of the fine or lien or regarding coming into compliance with code requirements during the required time. 3, whether there are existing code violations on other properties owned by the violator or prospective purchaser. 4, I believe, whether there is a development or redevelopment proposal regarding the property which would result in improvement or upgrade of the property. 5, whether given such development or redevelopment plan, it would be impractical to take compliance action directed by the board. And lastly, and whether payment would hinder a proposed sale of the property. Those are the factors that we've got before us that Mr. Salzman was referring to. So,
But the first thing we decide is whether we're going to take the case up or not, correct?
well, I think at this juncture, we've gone through all the testimony, and if there's any comments for deliberation that the board members have, I think I want to go through that, and if it dies for lack of a motion, it dies for lack of a motion, and if there's a motion, there's a motion.
Okay.
But I do think at this juncture, correct.
I just had to interrupt. I had a request from the citizen as to whether or not the board would entertain any comments from the public.
Oh, boy.
How many folks do we have who would like to comment on that? We have one. I'll give you 2 minutes. And this time I will time it. And I'll do that because we haven't stated our comments directly yet. Otherwise, I would have not done that.
This is my first time in 42 years attending one of these meetings, so I wasn't aware of whether it was appropriate or not. Certainly, if it's not, I'll be glad to sit in.
Sir, if you could speak into the mic.
Please state your name again for the record, because it's a
My
different
name
matter.
is Bonnie Sanchez, 762 Harbor Island. Been a taxpayer and a citizen of the city of Clearwater for 42 years. I've been driving by the building for the entire time, and I just want to make a couple comments. Number one, I want to commend everyone here, including the attorney for the Scientologists, the city and all, for conducting a meeting which I thought, in an inquiry or a discussion which I thought was excellent. There's an old saying that there are never any good or bad decisions, just good or bad facts, and I was very positively impressed with your quest for getting all the facts. And I've listened to them, and from my standpoint, it boils down to 2 things: whether or not you have the authority to comply with the city's recommendation to give them a fine of $413,000. Number 2, should it be reduced any further? Is there a hardship? I don't see anything that indicates that there's a hardship.
Let me just clarify one point, because the fine exists, and the only issue really is that of reduction. So keep it
I'm in
to that point.
complete accord with the city's number of reducing it to $413. Certainly, you don't want to fine them for something that they couldn't comply with. But as the old saying goes, your action speaks so loudly that I cannot hear your words. Based on everything that I've heard of the notices that they got on a quarterly basis, of the fines that were accruing, of the opportunities they had many times over the years, actions indicate that they were going to choose based on the history, and I think that's why they brought the lady to give the history of how many people, what's happened in the past, of the fine reductions and so forth. But it really boils down to 43 cases, and there's only one that's not been resolved, and that's this one. And I don't think you should set a precedent for future by reducing it any further. Thank you very much. I appreciate the opportunity to say so.
Thank you for keeping your comments brief.
Just to clarify for the record again, precedent's not an issue for the board. These are not identical situations. We've been doing this for 20 years. I can't tell you that we've ever had 2 cases that were the same for precedent purposes.
I understood, and I thank you for that statement, so the board can consider it. Do any of the board members have a perspective on this that they think the rest of the board should be thinking about as we consider a motion, if there's going to be a motion?
What's the total administrative cost that the city has expended on this case, on this violation?
I don't believe it's been calculated at this time.
Okay. So we don't have a floor.
I have a point, if you're finished.
We don't have an answer on that.
Well, it was stated that we couldn't go below what the administrative costs were, correct?
That is correct. However, I would say to you, based on what has been brought to you, the minimum that they're asked for is $43,000. So I would say that would be your floor if you're talking about that.
Well, unless the city believes for some reason that the administrative costs exceeded what they're proposing. If the city can tell us that it doesn't exceed that, we know what our floor is. It's been around since 2006, in essence. So as the city incurred administrative costs in excess of the amount that they propose to reduce this to is the best way to put the question.
That's.
I
didn't want to be not following what our.
We typically will try to calculate it. Actually, that's not a conversation we have for the first time with an applicant before they get to this board. So we've typically talked to them about what we see as the administrative cost after we've been able to account for that. I think this is a very complex case. It's gone on for a number of years, so it involves what at the time were two separate departments involved in the enforcement activity. So what I would respectfully like to do with the applicant, if that's the case, is that the board afford us as an opportunity, some period of time, in order to try to get a full accounting of what those costs are in this case, and then we will address that amount and with the representative, the violator, before coming back and go over those costs.
What I think we'll do in that regard is that if there's a motion made that is for a reduction, depending on the amount of that motion, that reduction, if we think we need to have a calculation of that, we'll go to that point. But I don't know what motion we're going to have, and I don't know that we can answer at the moment.
You add one comment to my comment is that typically this is a little bit of a unique situation in that the amount for which the representative is of the church is asking us to settle on is roughly equivalent to the amount for which we're willing to forgive out of the period of time. So there's a time frame in there in which to calculate our administrative costs that I think could be altered by whichever direction the board tends to go. So that's something that we would try to account for in terms of determining what those administrative costs are.
I think the relevancy of it, Mr. Strickland, will become apparent as we get to an actual motion, should we get to one.
Sure.
You can always make a motion that says X dollars and less.
But not less than the actual administrative costs, if that's an issue at that point in time. Okay.
I've heard over and over this afternoon that building code may not require completion of a building by a specific date. But permits do die date certain. And I guess I'm surprised that the church would not have been more aware of what they were allowing to go on while they kept on going on and wanting to build more and bigger and better, and so ignore that original permit. But that permit stopped, and nothing was done about it. The fine was put into motion, and nothing was done about it. Apparently it wasn't taken seriously, and apparently that means this board's order wasn't taken seriously. And that really bothers me right now.
Mr. Van Wezel, you have a comment?
I'll try to stick to Mr. Salzman's instructions. The first, whether the violation has been brought into compliance regarding the violation, etc. I don't believe a good faith effort was made to bring the violation into compliance. I don't believe that functional compliance is compliance, so I don't feel that criterion was satisfied. The second, whether extreme or undue hardship is shown regarding payment of the fine or lien, etc. I think everybody acknowledges that that is not the case here, nor is that the basis for the request made by the church. The other two whethers, the other whethers, I don't believe are pertinent to our consideration, whether there are existing code violations on other properties. That has not been brought up, nor has it been a factor that anyone has mentioned. Whether there is a development or redevelopment proposal regarding the property which would result in improvement, I don't believe that that's pertinent either. I think the two whethers that I did mention, and all the evidence that has been presented that are relative to those whethers, shows to me that this is an instance where this continuation of the fine process was one that was self-imposed by the church in the course of action that they took to choose to build more in as time went on. So I think I kind of feel, as has been stated, that this is an instance where the fine, or limiting the fine just to that time period, which is in question and which has been acknowledged by the city, would be a mistake. Now, to Mr. Strickland's point, I have no idea what the administrative costs are or would be. Were I to know what they were, I might be able to, speak intelligently about that. But deep down inside, I'm not sure that that's an issue either. I think the issues have been presented and discussed, and I'm not sure that mitigation is necessarily appropriate. Mitigation to me, or administrative costs, are more appropriate in the cases where there are hardships, where people aren't aware that things have escalated to a point where people are not capable of addressing the issues that were on the table, and I don't think any of those apply here.
Thank you. Does anyone else have any comments? I have a comment or two.
Well, the reason I asked the question about the amount was I didn't want to go against our own rules and regulations, but I think that some consideration should be brought into it in that they completed the building. I understand projects that size change constantly. You're trying to adapt and do things, and it looks like a very nice building. Never been in it, don't have a clue. But some consideration is that they did bring it into compliance, so that is, but I'm not stating that we should cut the fine.
Okay. Any other comments? I have a couple comments, but I want to let everyone else speak first. No? Okay. Then my comments on it is, and I'm not going to be redundant. I think that both what Ms. Cole and Mr. Van Weasel said are concerns that I had as well in terms of the length of time and whether there was a sincere effort to actually bring it into compliance. Had there not been testimony that the issue of the fines had been brought up over the course of the years, I look at two significant gaps in time. One we can't really do much about, which was from 04 to 06, because that was what the original order said, okay, now bring it into compliance, and things start running from there. But then the gap from even with their date of 07, if they thought in 07 that this thing was complete and that fine shouldn't be accruing, I really think it would have been incumbent upon them at $250 a day to bring the issue up, and it really is important for those kinds of things to be addressed. That being said, I think there is a concession on the part of the city that the time period to change things for the development order is a time period that does actually fit with one of those weathers a little later on. They were getting a development order that was taking this building and moving forward, and that took from the time period they were supposed to comply in June through the end of the year to get done, with the ultimate permit being issued in January of 2007. So from my perspective, the reduced amount that the city was looking at, bringing the fine down to a total of $413,250, if I got the number correctly.
$413,500.
500. I'm sorry. I knocked $250 off more inadvertently. My apologies. $413,500. I'm not as good at math either, Mr. Soto. Maybe it's an attorney thing.
Yeah.
But I think that from our perspective, that if you have an issue there and the city is looking at it and saying that, yes, we were working with them during that time period, but then things are ticking and nothing's really getting done, I think we should take that into account. I don't really feel persuaded by anything that's been done by prior boards. I don't think you have a project of this scope or type that's come before this board with this type of way of fines and compliance issues. And while I appreciate the statistical analysis comparing or starting out with 1,800 properties that with both expired permits and stop work orders, in the end of the day, that came down to a much smaller number of 43 that even comes close to looking at an analysis over a substantial period of time. I don't think this is that this is that out of the ordinary based upon the unusual circumstances related to this property. So, as chair, I'm not making the motion, but I will say that I think that if we're going to give any consideration to a reduction at all, we look at what the city was willing to concede to, and let things go from there. If there's no motion, then there'll be no motion, but,
Can I
Mr.
make a
Schultz,
motion?
you may make a motion.
Let's put this issue on the table. I move to enter an order that the fine of $451,500 be reduced to $413,500 for the time the violation existed.
Second.
I have a motion and a second. Do I have any further discussion on the motion? I know we've talked it out, but last opportunity to speak. There being none, all in favor say aye. Aye. All opposed? The motion carries unanimously. Thank you very much for your time. We still have a few more things on our agenda for those who want to stick around and enjoy the rest of the fun.
You know what, sorry.
You have a PowerPoint to introduce?
For the record, let the record reflect that we are introducing the city's PowerPoint presentation, project history, and commentary on this property for this fine reduction.